Hey, it's Brooke here today for Legal Talk Tuesday. It is the second Tuesday of the month, I believe, and that is Business Law Tuesday. So today I'm going to talk to you about 3 reasons why drafting your own contract is a bad idea. Um, so, you know, business friends, beware. It may be tempting to save a few bucks and grab a business form or template from an online search, or even maybe replicating something that someone else has shared with you or that you've used in doing business with other people. But that could leave you vulnerable, and it could leave your business vulnerable. So if you are a business, if you are conducting business, you're likely going to need a contract at some point. It's really important, especially if you are a service-based business. And so here are 3 reasons that you should be cautious about drafting your own contracts. One, you may not include all of the necessary provisions. So, you're likely piecing together parts of multiple documents found online. That's pretty common. But by doing that, you may actually leave out important information and things that need to be included specifically for you and to protect your business. So, business needs are going to vary from industry to industry and business to business. So, that should be reflected in your contracts. For example, independent contractor agreements, that's something that we do, but an independent contract agreement for insurance agents basically always is going to need a non-compete and a confidentiality provision. But like freelance web designers likely would not even agree to that, nor should they, that need be there for them to be bound by some kind of a non-compete or confidentiality provision in their agreements. So insurance agents actually have access to customer lists, confidential business information. If that is not protected by inclusion in the contract, then the result of that can actually be pretty, devastating to business. The second is that the law varies from state to state. So, doctoring a document from another state, that's kind of what I'm talking about. And it happens frequently. So the law is going to vary from state to state. For instance, a non-compete in California may fail to include things required for a non-compete in Arkansas to be enforceable. There was an example of a case not too long ago, a couple years ago, out of Western Arkansas, where a non-compete was found too broad, and that was, unenforceable. That was the consequence of that. So you don't want to find yourself in that situation. The third thing, you may not understand or foresee possible consequences that could arise from, in the future. So certain things are necessary to make a contract legally enforceable. You have to make sure that those things are actually included in your contract and that the execution of the contract is done correctly. So those are very important in making and creating and being able to enforce a valid contract. An attorney specifically is trained to recognize and identify potential issues now and in the future, not only things to include, but maybe issues that may arise that you haven't thought of around your actual contract language. So an example, if you're entering into a business partnership agreement, things are great, and there's all the love there, and you're in the honeymoon phase of business. So there are things that you don't necessarily anticipate happening that you want to include in your agreement. Or worse, you don't even think a contract is necessary, which that happens sometimes too. People just think, oh, we're fine, or we'll agree to it, a handshake, whatever. But the problem is that business divorce is a real thing, and you have to prepare for the worst. So you might not even know what that is or what that looks like, but an attorney with experience can help you anticipate some of those things, advise you ahead of time so you can be proactive and protect yourself on the front end, and also help you navigate the difficult stuff with your business partner if that happens to arise and you have that kind of neutral person there. So that's really important. I have been seeing a lot of document reviews lately. I've been getting a lot of requests for that. So at a minimum, it's best if you take care of these things on the front end, because on the back end, it's a lot more difficult to backtrack and put things in place that weren't already there. So at a minimum, have an attorney at least look at the things that you've drafted and review them, maybe give you feedback so that you can make sure that your contract is enforceable, that it does include all the valid terms, that you are protected, that it's specific to your business, your industry, to your needs, to your long-term and short-term goals. So you want to make sure that all those things are covered on the front end. So even if you've already created documents, or even if you have documents that you're using right now and you are operating using these documents, it's really important to make sure that a trained attorney has looked through those documents and given you feedback, because, we see them all the time, and sometimes by the time we see them, it's going to be too late for us to be able to advise you or help you in any substantial way, and that can be devastating to your business. So be proactive, protect your business, protect yourself. We do review documents that are drafted. Like I said, that's been something that's been really kind of ebbs and flows, but kind of end of the year, business clients pick up a little bit because they need kind of close out the year. So we do that. We advise on contracts before people enter into them sometimes. And then we always draft contracts too, if that's something that is needed. But thank you so much for joining me today. Those are three reasons you should not draft your own contract. And next week, Laura will be back here with me, and we will be talking about estate law. So I hope you guys have a great week. Thanks for joining.